All right. Well, welcome everybody. This is the free webinar of Understanding Estate Planning and Living Trusts. It is our introductory webinar for everyone who doesn't really know about estate planning or what it really even is, or what it's for, what it's about, all those introductory questions. My name is Michael Redden, and I'm the managing attorney here at the Redden Law Office. I've been practicing here in Minnesota for a while. As you can tell from my voice, I'm actually from Arkansas originally, but my wife and I live here in the Twin Cities, and we really love the Midwest and helping everybody out who's here. All right, so let's get started. All right, now if you have any questions during this webinar, please feel free to email them to info@reddenlawoffice.com. That's info@reddenlawoffice.com, and myself or my staff will get back to you as soon as we can, and we'll answer all of your questions. And again, any of those answers are of no obligation to you. We probably won't be giving any legal advice, but we'll let you know if you might want to talk to an attorney further about them. But otherwise, we'll answer your general questions at info@reddenlawoffice.com. All right. So a lot of questions people have is, what is an estate? Well, think about your estate as everything that you own, period. We're talking about your home, any kind of lake houses, your bank accounts, your investments, retirement benefits from your employer, your IRAs, any life insurance policies, things of that nature. Even we're talking about even collectibles and socks and everything else like that. And when you start adding that stuff up, it really kind of tells a lot about you and what was important to you. But when you add everything up at death, including all the benefits from your life insurance policy, so you may be paying $20 a month for that term insurance policy, but your estate, when you pass away, is going to get that full $200,000 or so death benefit added to its value. And if you think about it, when you think about that life insurance and those other things, you probably own more than you think. One of the most common things that we get is, I don't really own anything, so why should I have an estate plan? And we're going to cover over some of that today. So, why do you do an estate plan? Well, after you die, you can't take it with you. That stuff that you've accumulated over life, it stays back here on Earth, and long after you're gone, someone has to decide what they want to do with it. Most of the people that do an estate plan is because they want to tell people where their stuff's going to go. They want to control this. They want their children, their friends, their family, even their charities to get their stuff after they pass away. It's not just what happens after you die, though. It's also what happens if you become incapacitated. Now, unfortunately, a lot of people don't plan for this, but we always hope it won't happen to us. But at some point, a lot of us are going to move to assisted living. A lot of us are going to move to the nursing home, and unfortunately, a lot of times our mind, it doesn't work like it used to, and we could come a point where we can't make decisions for ourselves. And that itself is also a part of estate planning. A lot of people know when you die that there could be things like probate, but there is such a thing as living probate, and that's a probate for someone to declare them to be incompetent and take care of their affairs if they didn't do any plan for themselves. So who needs to do estate planning? Well, I would say that just about everyone does. Definitely the older you get, you start thinking about those kind of things. You want to transfer your assets to your kids, to your grandkids, look out for your loved ones, look out for their college and things of that nature. But, you probably should start thinking about that sooner, because even if you're young and just starting your family, what's going to happen to your children when you pass away? What's going to happen to your spouse? You may have bought that life insurance policy, but that just covers a big vat of money coming in. Where do you want that to be spent? Even if you don't have a family or anything yet, if you have significant property, if you've bought a home or anything of that nature, you want to tell everyone what you want to happen with this, where this is going to go, because the folks left behind are going to have to deal with that and disposing of your assets, not just your burial. Let's give you an example here of a couple of estates. This was Elvis Presley's estate when he passed away. He had about $10 million total. It's a lot of money even now, but it was a whole lot of money back then. And then he had to pay about $3.8 million in debt. He had to pay administrative, legal fees, and executor fees because there were some things for probate there. And then, of course, the government came by and picked out some estate taxes. So Elvis just had a will. He didn't have a trust. He didn't really plan for taxes or anything of that nature. And so, as you can see here, more than half of his assets went to the federal and state government or to lawyers and executors' fees after his debts were paid. He had $10 million, and less than $1 million went to his heirs. That's the first example of why you really need to have a well thought out estate plan, and sometimes not even a will is enough. Now let's look at Groucho Marx. He got declared incompetent by the court, okay? He didn't plan for incapacity. His mind started to go, and someone had to take care of him. So a judge declared him incompetent, that he couldn't take care of himself. And because of that, all of his personal affairs, they were in the public eye. Here in Minnesota, this is called establishing a guardianship and conservatorship, and all of his financial assets and dealings, well, what happened with them? They ended up in a court file that anyone coming down to the courthouse had a right to go read. So all of his private business was in there. Anytime there wanted to be major changes or anything of the like, those things had to go through the court itself. He lost control of his assets. He couldn't decide where his things were going to go, where's money. He couldn't decide where he was going to live. He couldn't decide to just go buy a new car. He lost control of his personal decisions. In some instances, he couldn't even vote. And he couldn't decide just to go on a vacation anywhere. Probably couldn't even pick his doctor. And again, we've covered how he lost privacy because everything was in the public record, and all this is cost because the court has filing fees. If the person who takes care of you isn't related to you, you're going to have to pay them. And on top of that, there's going to be costs for lawyers because anytime we go to court, just about, we're going to have lawyers be a part of the process. So when should you plan? You should plan now and often. You should plan before you need it. You don't want to be dealing with an estate plan and where things are going to go or where things might go if you're sick or if you're in hospice or if you're about to pass away, because there's going to be a lot of other stress going on at the time. People are going to be worried about whether or not you got your arm twisted. And you're just going to want to take care of you at that point. So we say you should always start planning now and plan often. The plan you have now might not be the plan that you're going to need in 5 years, so you're going to come back and review that at some point. And again, you do it while you can. If you're like Groucho and you end up start to lose your mental faculties a little bit and not be able to follow things like you used to, then you might be incompetent. And everyone might know from listening to television and everything, even when you sign your will, your people are signing and saying that you are sound mind and body. If your mind's not sound, you can't make this plan. So it wouldn't be even good for you at that point, because you get no second chance. Once you're incompetent or once you're passed away, you don't get to come back and do it again. Once you're incompetent, you can't change any of these things. So you want to get your plan down, and you want to get it formal in writing and make your loved ones know about it being there. Now, there are several different kinds of estate plans that people kind of deal with here. We'll go over each one of them in turn. The first one's having a will. The second one is just doing nothing. I'm going to let the kids, I'm going to let everybody just take care of it. That's going to be their problem. The third one is joint ownership. We might have a joint banking account. We might hold our real estate as joint tenants with right of survivorship. We might be joint on our retirement accounts. We might have told our retirement accounts and everything like that to have a beneficiary that goes down to the beneficiary transfer. We may have a pay on death benefit on any of these accounts. And then we could also just decide we're going to give away our assets, so that hopefully by the time we pass away, there's nothing really left to worry about or probate. And then there's another option, a revocable living trust. And we'll go through each of these in an overview. Let's start with the will. This is the one that everybody knows about. Just about everyone knows what a will is, and everybody knows what they can expect with the will. In a will, you express your wishes. You say, I bequeath, I give this to this person or that person. and everything else I give to a charity, I give to my mother-in-law, or I give, some people have even given it to the United States government for the use in paying down the debt. But did you know that a will only controls assets that are titled in your name? It doesn't control assets that are in that joint ownership with your spouse. Those go straight to them. Or joint with anyone else, whether it's your cousin, your business partner, or anything of that nature. And it doesn't control any assets with a beneficiary designation. Your IRA makes you say, you know, if you pass away, where does this go? And a lot of us don't even keep that stuff up to date. And if we don't keep that up to date, then it doesn't go where we want, because it certainly doesn't come back into the will to be handed out. It goes straight to that person. So your will doesn't control all of your assets. Now, any of those assets that you don't control, after you die, it has to go through probate. So if your IRA does not hand out that beneficiary, anything of that nature, then it's probably going to cause a probate, even if it goes back in through your will because of the amount of money that's there. And, you know, of course, probate's going to be enforcing your will at any time. You know, some people might not agree with what you like or what you want to do, and they can contest your will, and everyone will have to go to court and talk about what you really wanted or how those things kind of went. And it can be an expensive and timely process. Well, what is probate overall? You know, it's a process where they're going to validate your will. They're going to say, yes, this will is in the proper format. There were 2 witnesses. It looks to be like a true, valid will. And then they're going to pay your debts first, and then after all the debts and things are paid off, they're going to give your assets out to those people that you named to give them to. Now, one thing to mention, in Minnesota, we have several different kinds of probate. Informal probate, you know, that usually doesn't even go before a judge, and it tends to be faster, but, you know, still most people will hire an attorney and pay some fees, even in informal probate. Supervised probate is just like you think. The judge is there looking over all the process. He's approving every one of those major transactions. There's an accounting coming forward, and he is really detail oriented into the estate. And of course, all this still goes out into the public. It's a part of the public record for anyone to see. And it's the only legal way to change title after you pass away if you did not have your assets in a trust or in joint ownership. To give you that kind of illustration here, this is how the assets kind of go through it, okay? Everything that's out there that you own that doesn't have a joint ownership or that you didn't name a beneficiary for, it comes into this funnel of probate. And then, you know, you can think about taxes and your fees as, you know, someone cut a little hole in that funnel and some of it's leaking out, and whatever's left and doesn't leak out comes down through to your heirs. Of course, it's pretty big business. The American Association for Retired Persons, AARP, did a survey a few years ago, and it found that nationwide, attorneys' fees alone could be as much as $1.5 billion a year, and that hundreds of millions more go to bonding companies, appraisers, and the probate courts themselves. You know, this is one of those necessary evils. If you don't provide a plan for yourself, we have to have some kind of system to show where your stuff should go. And if your family disagrees on who should get something, then the court has to decide this. And having an estate plan is one way to save your heirs a lot of time and money and heartache, because you've planned for this and you set your wishes out and you've avoided probate if possible, if that's your desire. The costs vary in every state, but usually they're about 3 to 8% of an estate's value. So if you had that $200,000 there, you're going to be paying potentially up to $16,000 if he has to go to probate and to go through all these formal proceedings. But a good estate could prevent that. How long does it take? Again, the informal probate, sometimes these can take 6 months, 5 months. You don't know. We've set that process to be faster, but you never know what comes up. On average, the survey found it'd be 9 months to 2 years. And again, there's no privacy. Everything's in that court file. Anyone who has an interest in it can come up and ask your heirs, hey, you want to go challenge this will? You want to get some more on probate? You should really hire a lawyer. And there are some actual solicitors out there, some unscrupulous people who will go find folks in these probate files and know what they have for assets, and then what you have for assets, what may be coming to them, and they may come and try to buy them from them, take them from them, get them into the probate process. It's just a very complicated industry and a complicated process that you really don't have to put your family through if you have an estate plan. Probate has control of a few things. How your will is interpreted, not your family. They're not going to decide that you said you wanted this to go to that grandchild, but you really meant that it should go to someone else if they don't want it. They're going to interpret it based upon the law. It has cost, it has time, and it has privacy. Those are all the things you're going to lose. Really, estate plans are about control, and so is probate. Now, a will is no help if you become incapacitated. Wills only come into effect after you die. Remember we talked about Groucho earlier? Now, there's a court process if you become disabled, either physically or mentally. It could be Alzheimer's or something else. There's a court process. It's time-consuming. You're going to have a guardian named to look after your person and make your personal decisions. You're going to have a conservator named, and in Minnesota, the conservator is going to control all of your money and assets. And it's going to be the conservator's job to make sure your money is spent properly and that no one's taking advantage of you. And they're going to pay all your deals. And there's a real life story that kind of goes along with this. There's a guy named John. He got Alzheimer's. His son Mike, he needed to sell his home so he could pay for the medical cost. But Mike, he couldn't sign those papers because John's name, his dad, was on the title. Mike had to put his father through this, had to declare his father incompetent, public to the world, and spend all that time and money just to have him declared incompetent so Mike could become his conservator. And then so he could sell the house and pay for the nursing home. And he had to get the court's permission to sell the house. The court had to overlook the sale and make sure that it was being sold for enough money and approve everything. And it was very time-consuming and expensive. In the meantime, John racked up debt, and John even had to go on state assistance to get his care taken care of. And while there is no silver bullet for that, a proper estate plan can include power of attorney and things that are signed well in advance so that if something happens to you, your son can take care of that, and he could have sold that property without having to go to the courts. Now, if you've got children, especially if they're minor children, you really need to have an estate plan fully in place, okay? It might not give you the control you want, though, if you have just a will and the children underage. Because of the Uniform Gifts to Minors Act, if you pass away and you've left money to your grandchildren or any children that are under 18, the court will then have to appoint a custodian and a guardian for that money so that that money can be watched over for them until they become the age of majority, and all that's in the court record, and all those accountings are in the court record. But what if you and your spouse both die and you have these children? Well, someone's going to have to be named the guardian to take care of your children for the rest of their childhood. And, the court, if you haven't left the will and haven't left the proper estate plan to name your wishes on where they're going to go, they're going to look to the family and say, who wants to take care of these children? And whomever steps forward that the court thinks is best on their standards, not yours, will be named the guardian of your children and get to take over raising your children for you. So you want to make sure it's someone that shares your values and that your children know and like and love, and those kind of things. Your second type of plan, and the children do inherit everything when they reach the legal age of majority at 18. Your second type of plan is to do nothing. So at death, there's going to be a probate, and the government's going to come in, and we're going to gather all your assets and decide how they're going to go. Normally, they look to a will to see where the things are going to go, but since you don't have one, it goes to state law, and that's called the law of intestate succession. And in Minnesota, if you're married, and so long as you don't have any kids from a previous relationship, then half of that's going to go to your spouse, and the other half kind of be held for your children. If you have a child from a previous relationship, half of that's going to go to the child of the previous relationship, and the other half's going to be left over to go to your children. Excuse me, your current spouse. This is probably the worst situation you could be in because you have no control. And at your incapacity, of course, we didn't plan for any of that. We've covered guardianship and conservatorship. The court's going to where they go. The third type of plan is the joint ownership plan. A lot of this people put our houses and things in that way by families, and it's called joint tenant with the right of survivorship because if you pass away, the other joint tenant gets it. Some people think it'll avoid probate and give them the kind of control they want, but let's meet Tom and Ann and their kids here. So Tom and Ann, like a lot of married couples, have their home there, and Tom, unfortunately, he died suddenly in an accident. Immediately upon his death, Ann automatically gets sole ownership of the home. There's no probate for that. But what happens when Ann dies? Is there a probate? Absolutely. That's the only way to get her name off the title and put someone else's name on because Tom's title left when Tom passed away. So you see, joint ownership doesn't avoid probate, it just postpones it unless Ann does something after Tom's death to plan for that going forward. And this can happen the same thing for your IRAs and any kind of other things that happen that way. Let's meet Dan and Ann. So what if Ann remarries and puts the house in joint ownership with her new husband, Dan? Well, if Ann dies before him, then Dan gets that house, and he's under no legal obligation to give anything to Ann's kids. In fact, if they have children of their own, maybe he gives it to them or he just keeps it. Ann could have inadvertently disinherited all of the children she had with Tom together because that home did not go there, neither did any of their joint assets. And even if Ann had written in her will that she wanted these shares of the house to go to the kids, it wouldn't make any difference. It wouldn't be legally effective because the title was held that way. It doesn't go through a will when it's held in joint ownership with the right of survivorship. So for the summary, it just postpones probate. It doesn't stop it. It can result in the unintentional disinheriting of former children from previous relationships if the surviving spouse remarries. Court still is going to interfere when there's incapacity and take control of the assets. And it's difficult to remove that co-owner at any time. If there's a reason you want to remove Tom, maybe he has become incapacitated himself and you want to just put it in Ann's name so that Ann can take care of things. Maybe you're doing some Medicaid planning or some other things of that nature. Most of the time that won't work for Medicaid planning, but if it happened to be your sister, your cousin, your business partner, and you want to get their name off the title when they became incapacitated, that would be difficult without a court intervention. The court would have to see what was in the best interest and fight for their rights. It would be very difficult to take their name off. Also, it doesn't protect you from lawsuits. Any kind of lawsuits that come about for joint ownership, if there's a judgment that's found against you, it doesn't protect from those creditors. They can have the sheriff come in and seize and sell the property, whether it's your house or something else in most instances. It just doesn't make it protected from that, whereas some other forms of planning can absolutely protect from those things. And any kind of other debts or tax problems you have, if taxes come up from your business owner or anything like that, then those just are going to be problems for every one of those assets. Now the other ones, you're going to give away your estate to other people who can use it. And parents often do this for their assets to their kids, thinking, it's going to be easier if I'm not around or I'm going to pass away. But what happens if you want that and you need it later? What if you give that money away and then now you need it later to pay for your care? What if you gave that home away and you improve and you want to come back home from the nursing home? You may not have anywhere else to go. So you say that might not happen to me, but you never should say never. This happens more than you think. Estate planning is planning for the worst and hoping for the best and getting the best plan we have because nothing's ever that golden bullet. To give you kind of an example, there was an elderly couple, and they were named Frank and Elizabeth. And they put everything they owned, including their house, in their married daughter's name. A year later, Frank, he died. And several months after that, their daughter died in a car accident. Elizabeth, she never thought she would survive both her husband and her daughter. But you know what? Everything that she owned now is going into probate because her daughter died without a will, and her son-in-law was fighting to take it all. Or worse, you give it to them, and then they get divorced, and they take all or most of it in the divorce. There's a lot of things you should be thinking about. Give away your assets rather than have them properly passing an estate plan is with taxes. Let's give you an example. Let's say Bob, He bought his house for $100,000 back when he first bought it. Today it's worth $350,000. He gives it to his son Tom, who then sells it for $350,000. Because Bob transferred title to Tom while he was living, the house keeps Bob's old cost basis of $100,000. That's what Bob paid for it. That means that Tom now has a $250,000 gain on that sale when he sells it. And under the current tax law, he'd have to pay about $50,000 in capital gains tax. Now let's look at what happens if Bob left his house to Tom as an inheritance. At the time that Bob passed away, the house was worth $350,000. The basis is not going to be that $100,000 of what he paid for it. It's going to be the fair market value at the time that Bob passed away. So Tom gets it, and if he sells it right at $350,000, there's no tax gain and no capital gains because we have favorable tax treatment on inheritances. Now, let's look at beneficiary transfers for things such as life insurance and things of that nature. Now, what happens if your beneficiary themselves becomes incapacitated, dies first or at the same time, things of that nature? Many of our assets, including the life insurance policies, IRAs, retirements, and bank accounts, they let you name that beneficiary. And when you die, that gets paid directly to that person, you think, but not always. If your beneficiary is incapacitated, the court will take control, because remember, you've got a guardian conservator. It's got to go through that court file. Nothing's private. Everyone can see it. So can the government get at it too if they happen to be on public assistance? It could even affect that public assistance. Well, if they die before you or you both die at the same time, that asset's got to go through probate, and it can be distributed to the rest of your estate if you die simultaneously. If they die before you and you didn't state an intention, it might be going in that child's estate or that grandchild's estate to their kids, their husband, their wife, things of that nature. And if you list that minor child there, the court's going to have to get involved anyway because they're under 18, remember, and we need to have someone look out for their interests. So they're going to have a Uniform Gift to Minors Act custodian, and they are going to report to the court everything they do with that money until the child turns 18. Now, the thing that gives you the most control is a trust. It's being used more and more by people of all ages, marital statuses, and wealth because the will has those other issues, so these other plans, and this kind of gives you the most control overall. So let's take a look at it. First, we'll compare them to a will. Trusts and wills have both been used for hundreds of years. In both, you name someone to handle your affairs after you die. It'd be the executor or the personal representative of the will, be the trustee under the revocable trust. In both, you name who you want to receive your assets after you die. But unlike a will, the living trust avoids probate when you die, and it can control all of your assets and prevent the court from controlling the capacity. If they're in that trust and you become incapacitated, then you can name a trustee who takes over when you become disabled. So if the trustee makes all those decisions, it keeps everything private. It's not in that court file. No one can see your business. No one can really challenge those things on most instances. And you have control and your privacy. Now, when you set up your living trust, you're going to transfer your assets from your name into the name of your trust. So, for example, from Bob and Sue Smith, husband and wife, to Bob and Sue Smith, trustees of the Smith Family Trust, dated April 1st, 2017. This is called funding your living trust. We can kind of show here, there's nothing left to probate in these kinds of things because all of your assets aren't in your name, so there's nothing to put in there to come out and those kinds of things. Now look over at the trust when you passed away. All those things are in the trust. So the trust lives on after you die, and according to your wishes in the trust document, the trustee gives things to the beneficiaries and things of that nature. But there, there could be some tax things going forward because trusts are taxed as well. And the things that you're giving into your trust when you pass away are counted for estate taxes. You can keep control as the trustee. You can buy and sell your houses before. You can buy and sell cars. You can buy those things. You're the trustee signing it, and you're buying it in the name of the trust. You can change that trust at any time. That's why it's revocable. You can say, I want to change this whole thing around and have things go this way and that way. I don't want these trustees. You can say, I want to undo this whole thing completely. Get rid of the trust and put things back in your name. You have all that control, and it contains all of your instructions. And how does a trust basically work? You got the grantor, that's going to be you and your spouse. You're going to create that trust, and you're going to put all the assets in it. Oftentimes, you're going to control it. You're going to be that first trustee. And because you're a grantor trustee, the IRS isn't even going to treat it as a different person. It doesn't need its own employer identification number, its own EIN, unless your bank requires it of you. And you're not going, even then, you're not going to file a separate trust return. You're just going to file your normal regular tax return, include any income from the trust, any deductions from the trust in your regular income. So you have a 1040 like usual. The trustee is going to manage your assets. If you can name someone else if you want. You have instant control with no court interference, especially if you and your spouse are. And if one of you become incapacitated, the other spouse can take over. Both of you, we have a successor trustee that we can come up with. And that successor trustee is going to step in for you when you're incapacitated or even when you die and control those kinds of things. And then after you pass away, the trust is going to talk about how you distribute those assets. And the trustee is going to have to distribute those assets in accordance with your wishes. Choose a couple of people to your trustee. You can choose a corporation like a bank. They're experienced. They have professional asset managers that even will invest your money while your spouse is alive, so maybe they can get interest in things of that nature, invest it to grow it while you're trying to pay for grandkids' college and things like that, and they're going to protect it. They're also regulated by the government, so they have to have licensures and insurance, and they're subject to audits and things of that nature from the government agencies. A private trustee, just an individual out there, probably is not going to need any kind of those. They have no special requirements other than that you trust them, and they accept that responsibility. These guys are reliable. You know, they're not going to say, "Oh, I know I told mom and dad that I'd oversee this when they were alive and make their estate plan, but now that they're gone, I just can't do it. I don't want to do it. I can't." They're going to take it, and they're going to do it, and they're going to perform the functions. And they're going to keep your objectives in that trust document at heart. There's sometimes no guarantee that a family member or someone like that nature is going to follow it. We can trust them, but there's no guarantee they're going to follow it. These banks and things like that are much more likely to follow it because they're most likely to get sued. You control your inheritance in the trust. You can give it to everybody all at once. You can give it to them in installments at certain ages or just yearly. You can say that they just get the income from the investments and not the investment itself, so it lasts generations potentially. If anybody has special needs, you can put it in a special needs part of the trust so that it's not counted against government benefits and just helps them while they're while your special needs child or relative needs it. It just helps them and goes to anything that the special assistance doesn't pay for. It can give them supplemental income as well to use for things going forward. And minors, we don't need anybody to come in to take custodianship of this because the trustee already has it. And a lot of times, if the trust is written properly, those kids, if they're irresponsible or if they have other social issues, it protects them from their creditors or from someone taking advantage of them because the trustee's in the middle there, and if the trust is written right, creditors can't get at it, and the trustee's not going to let them get swindled. I'll give you a summary for a living trust. It avoids probate at death, prevents court control of assets if you become incapacitated, provides your maximum amount of privacy because it even keeps things out of that conservatorship if you're at incapacity. It allows for a quick distribution of assets to beneficiaries because the courts aren't involved talking about where they should go and validating anything. The trustee can just give those out in accordance with the trust document. And it keeps all that assets in the trust so things don't go out to other people if there's a death or a divorce or things of that nature. And it prevents you unintentionally disinheriting because if everything was in that trust and Anne went and got remarried, Tom's part of the things in that trust would always say, it stays here and helps Anne while she's alive, then goes to my kids. It doesn't become a part of Anne's estate to give to a future husband. And it can reduce or eliminate estate taxes if you're one of the people who have to deal with that. There's not too many who have to deal with it anymore, but some of us do. And you can plan for that and reduce or eliminate them through a trust or through a will and other things. There's not a whole lot of estate tax planning you can do. Let's see, for your medical decisions, the concept of a living will, it's called a healthcare directive in Minnesota. But they're kind of the same thing. It is basically a power of attorney for health issues. We have a power of attorney for your financial issues, so people can sell your house, control your money, and things like that, just like the conservator controls all your assets in incapacity. And then we have the healthcare directive to control your healthcare decisions, life support, cremation, any of those wishes you have, like a guardian would. So it's kind of two documents that fill those roles and try to help you prevent needing to go to living probate. It also includes those HIPAA authorizations and things inside there so they can get a hold of your medical records and things of that nature. HIPAA kind of does so when you're doing that healthcare directive, those HIPAA authorizations and everything will be drafted up by you or your doctor so that you can fill that final piece. So what's your action plan for an estate plan? You should write down your objectives. Who do you want to receive your assets after you die? When do you want them to receive it? Who do you want to manage your financial affairs and make medical decisions for you when you can't? You want to take an inventory of all your assets and your debts. Find out how much you own, how much is owed against it, so we know exactly the value of that estate. You want to get professional help. Find someone that you're going to be comfortable with, who can answer your questions, who will be there when you need him or her. And you don't just need an attorney. You need your insurance professional, you need your accountant, because together they're going to be able to come up with the best estate plan. I work in collusion with all of your inclusion and collaboration with all of your other professionals. I don't replace your insurance guy. I don't replace your accountant. We look over it together so that each of us in all of our specialties will be able to provide for you what's needed and give you the best advice. 3 heads are better than 1, and we will produce the best estate plan. And you want to have all those legal documents prepared, and then you want afterwards, if you got a trust, you want to change the title of everything to a living trust. A trust is no good unless it's funded. It's no good unless it's funded. If it doesn't get into the trust, it's still out there for probate. This is the most commonly overlooked part of a living trust. Once you have one, all of your assets need to go into it, and anything new you get needs to be put into that trust. I can't stress it enough. I hope you've enjoyed the introduction webinar to estate planning and living trusts. You'll be able to come back here and look at these things over and over. And if you do have any questions, please feel free to email them out to the firm. We'll get you a response to that. And when you set up a living trust, I'm telling you, you're going to be able to relax with your family and friends. You're going to know you've got good planning with a happy ending, and that will give you the biggest benefits of all, peace of mind. But you know, trust is not for everybody. But if you don't go with the trust, I encourage you all to have at least some kind of estate plan, whether it's a will and power of attorney, or a trust, a will, power of attorney, and all that together. If you do like having more information, you may be getting some emails from my firm offering some more free information and gifts. Otherwise, please come to our website at www.reddenlawoffice.com, and you can book an appointment either by calling our office at 763-515-0478 or emailing us at info@reddenlawoffice.com. Have a nice day.